Welcome to the Thrive podcast with the Shiloh Missionary Baptist Church.
How does your faith kind of play into it, or does it play into it?
What can be done about it? When I say the church, I'm talking about evangelical white Christians and the black folk who attend their churches.
Hello, welcome to the Thrive podcast with the Shiloh Missionary Baptist Church. I'm Fred Jeff Smith, pastor of Shiloh, and I'm very happy that you're either viewing us on YouTube or Facebook, or you're listening to us on iTunes, Spotify, or Amazon Prime. As always, we invite your input. You can reach out to me at fredjeffsmith@gmail.com, fredjeffsmith@gmail.com. Let us know how we're doing and what we can do to make the podcast better. I'm very happy today to welcome back to the Thrive podcast Ms. Vicky Jones, who is running for 19th Judicial District Division O District Court Judge. Vicky, welcome back.
Thank you. Thank you for having me again.
Notice I didn't call you Veronica.
Thank you so much. Thank you.
Her name is Veronica, but she likes Vicky.
Only my mother calls me that, and Donovan when he wants something.
Okay. So tell me, you were here, as this is being recorded, you were here a week ago for the debate, and I'm sure that you've been in several of them during the course of the campaign. How do you think the debate went?
Oh, I thought it was really good. It was very professionally done. I mean, the setup was awesome. Questions were good. The attendance was good. Good. I've been watching how many people have actually, been watching it. Mm-hmm. Yeah, viewership is also very good.
Well, good. I'm glad. We have done several of these now, and I'm always curious to see how the participants feel about it. So I'm grateful for that. How do you feel like your campaign is going as you're nearing the end? As this is being recorded, we've already started early voting. So how do you feel like your campaign has gone thus far?
Campaign is really good. There was in the beginning, because of the redistricting, there was we had to redirect, reshift, and, reevaluate the whole process because we actually started campaigning, or at least started talking about the campaign, and probably late April, May, and, had a strategy based on the old district, which was only 54,000 voters. Well, now it's closer to 150,000.
Right.
So that caused some major, revamping.
What do you think was behind Representative Freiberg's push? I know the legislature did it, but she pushed for this remapping. What do you think her motive was?
She told you her motive. She said her motive was to get rid of black judges.
And how does that make you feel as someone who aspires to be a black judge in the 19th JDC?
I guess it's concerning to me, the statements like, in order to have qualified judges, we have to redistrict. To me, that's saying that you can't have qualified black judges. And of course, I strongly disagree with that. And I think that from her and those supporting her had a lot to do with the makeup of the court as it is now. There are 9 black judges and 6 white judges. And I think the idea, and this was also said, that next year, in 2026, all of the judges will be running, all 15. And it was also said that the anticipation was that in 2026, under the current map, there would be 10 black judges and 5 white judges. So what was said was that they needed to be even. We need to have an even number of judges. That likewise is concerning me because we have other courts other than the 19th JDC. You have the First Circuit, which is clearly not even, and also the Supreme Court. Those are not, evenly apportioned between blacks and whites.
One of the things that concerns me, and I said this the other day when Mr. Thomas was here, I have the luxury of being able to look at these things through the filter of race. You don't necessarily have that luxury or want to take advantage of that luxury, and I understand that. But I see it as purely racist intent on the part of Ms. Freiberg and the legislature and conservative Republicans who want to assert their power as they currently have it. What, in the case of the 19th Judicial District, what difference does race make? How does race factor into a judge's seat? You're following the law. You're not looking at
Right.
things from the standpoint of, well, it's a black defendant, so or it's a white defendant, or it's a Hispanic defendant. You're looking at it from the standpoint of the law. So I guess I'm just asking you to speculate. What do you think the motivation behind this racial component is? I can understand it for other seats. I can understand it for the Metro Council. I can understand it for the school board. I don't see where that factors in to the same extent when it comes to the 19th JDC.
I mean, I would agree. As far as judges are concerned, it shouldn't be a factor. But based on what was said at the hearings, and what's always gone on regarding the redistricting and the minority sub-districts, that seems to me to be more political. Because as far as what a judge does, it shouldn't make a difference whether they're black or white. We always say that it doesn't make a difference as far as the people that come before the court, but it shouldn't make a difference as to who's sitting on the bench as well.
Let's get into the particulars of the 19th JDC. I looked up a little bit of information in preparation for our talk. Currently, there are 1,197 people being held in parish prison with a capacity of 1,200.
Wow.
So that's like 95% of capacity. Are these people being held awaiting trial?
Well, everybody that's there is awaiting something, maybe not necessarily trial. Anybody that's going to be in parish prison, that means they've been arrested for something. That can be a new offense. That can be a probation violation. There are a number of reasons that could have gotten them there. And so it just depends on what stage in their process they're in. Some of the people that are in parish have not been arraigned. So it's not always they're waiting for trial.
Which leads to my next question.
Right.
Keep going.
They
Finish
may
your
be
answer.
waiting for arraignment. I mean, you can have, other motions that are pending. If it's a probation violation, they may be waiting for that a hearing, a revocation hearing. So it's not always they're waiting for trial. The idea of them being there awaiting trial is a misconception because there are other stages in the process that they can still remain in prison until those are resolved.
You mentioned arraignment. Back in 2019, I believe it was, there was legislation put in place to have 72-hour arraignment of everyone who was arrested and being held in parish prison, the goal being to reduce the number of people that were actually in parish prison and to help speed up the trial process. As we sit here now, with 1,197 people in parish prison, not knowing why they're there, from your assessment as someone who works in the judicial system, how does this 72-hour arraignment situation seem to be working? Or is it working?
I think it's working fine because remember, you have to be arraigned. And that only says you enter a plea. That doesn't dispose of your case.
I understand that.
Yeah, you're still there. So I don't think the problem with people being in parish prison is that they're waiting on arraignment. I think the backlog comes more in the court system itself.
Okay.
Because the majority of people that are in parish are not waiting for arraignment. They've been arraigned.
Okay.
You're waiting for your case to go forward.
Okay.
So I don't think the new legislation, is why you have such a high number of people still in parish.
Do you think the bail system has anything to do with that?
To a certain degree, because there are a lot of people that are unable, after you're arraigned or after you're arrested, bail is set. A lot of people can't meet that bail.
Right.
But I don't necessarily think that means bail is the problem, because your bail may be low. You may have a low bail, still doesn't mean that you can make it, that you can pay, and bond out. So in some cases, you have bonds that I think are high, but I don't know the facts of all those cases, so I can't really speak specifically to those bonds. But I don't think that based on your question, that it's bail that's the issue, because some people just won't ever be able to bond out.
Follow that a little bit further. What do you mean they won't ever be able to bond out? They simply can't afford bail?
Some people can't.
Okay. What kind of discretion does a judge, hypothetically, not you in particular, but hypothetically, what kind of discretion does a judge have in setting bail? Is it done by law? The law says that a bail must be between X and Y?
No.
Or is it up to the discretion of the judge?
It's the discretion of the court.
Okay.
I'm trying to think of a situation where it's not, but generally it is. It's it's your discretion, and that should be based on that the offender's criminal history, the severity of that offense. There are factors that would go into setting bail. You have to consider what the offense is, what grade of offense it is. And like I said, couple that with the offender's history.
Is there any such thing? I watch a lot of Law and Order. Is there any such thing as being let go on your own recognizance?
Yes.
Is that a real thing?
We call that a sign-out bond.
A sign-out.
Right. You sign
bond.
yourself out.
Okay. And does that happen
Well,
with
let me clarify.
with any degree of regularity?
You can be signed out. You can sign yourself out in some cases. That's the ROR on your own recognizance. Or you can also get a sign out where somebody else is actually signing you out, meaning that person now is responsible for making sure you make your court date.
Okay.
But we also have to distinguish what court you're in, because we also have city court where they handle misdemeanors, but you also have the same thing. You have the arraignment, you have the bail, you have bond set, you have the RORs, you have the sign outs. All of that exists in both of those courts, not just in district court.
I understand that. I'm just trying to determine if there are 1,197 people in parish prison currently awaiting trial. I'm trying to determine what ways can be pursued to reduce that number. Is there not, going back to my basic civics, is there not a constitutional right to a speedy trial? And who determines, or how is it determined whether or not a person's trial is speedy?
Okay, a couple of things. Let me talk about the bail situation first. So you're telling me how many people are in parish prison awaiting, trial or waiting to go to court. But what you're not saying is how many people are out that are not in prison who are still waiting for their cases to be adjudicated. We don't
I'm
know
also not telling you how many people have been transferred to other places to be held because this prison is at capacity.
Right. We don't know those numbers.
Correct.
So without knowing those numbers, I don't have any way of saying, how that factors in, because I don't know how many people, were able to bond out and who are still waiting for their cases to be adjudicated. We don't have that information. But with respect to the speedy trial, everybody is guaranteed the right to speedy trial. But there again, a number of factors, case by case, go into whether or not you go to trial and when your trial is.
What constitutes speedy, in your opinion? And I'm sure it has to do with what you're charged with, but if we're talking about a breaking and entering case, what constitutes a speedy trial?
Okay. Well, let me answer it this way.
Okay.
The things that delay trials, let's talk about that.
Okay.
You have continuances by both sides, either by the DA or by the offender's attorney. You can either have it on the defense or you can have it on the prosecution. So there's no, one size fits all. Because even minor offenses, their continuance is still requested on both sides. So it's not, you can't say, oh, it's a minor offense, so therefore you'll be to trial next month or next week, and that constitutes your speedy trial. Because even in those misdemeanor cases or nonviolent crimes, you still have the same requests for continuances on both sides. So that delays the trial as well.
What, in your opinion, is a valid reason for a continuance?
Oh, gosh. I mean, there are a lot of that. I mean, I can't give you one valid reason for a continuance because, I've seen request for continuances for a myriad of reasons. So there is no one size fits all on that one either.
I guess what I'm trying to get to is Hiller Moore, the district attorney for this parish, estimates the backlog of cases in his office to be between 11 and 12,000. That's a lot of folk.
Absolutely.
A lot of people who are awaiting trial. And I know that it's not the judge's fault that there are 11,000 people awaiting trial, but I'm trying to figure out what role a judge can play in helping to reduce that number. Is there something that is within a judge's discretion that can kind of punch a hole in that number and get it reduced?
Yes.
Hypothetically, so I'm not talking about you in particular. I'm talking about just hypothetically speaking. 11,000 people awaiting trial, that's a whole lot of folk.
It is. Okay, but again, you have to look at, Hillamore also says that his office is very understaffed.
And underpaid.
Well,
Underfunded.
Underfunded.
Right.
I'm only going to relate it to staffing because
Okay.
that's the only part that would relate to court. If you don't have prosecutors in the courtroom to move the cases.
Well, he talks about investigators and having proper personnel to do investigation. Would that be included in what you're talking about when you say staff?
Yeah, I don't know the inner workings of his office, but let's say that you're using his example for investigators.
Mm-hmm.
Well, his investigators have to do the investigation before the case actually proceeds. Well, if you have a lack of investigators, you have a lack of attorneys, then we can't move the cases forward if there's no one to do it.
Mm-hmm.
That's one thing. As far as what a judge can do, I mean, there's this idea that because somebody requests a continuance, you have to grant it. And that's not the case. I mean, just because either side requests a continuance, a judge has the authority to evaluate the basis of that continuance and either grant the continuance or deny it. So I don't know in individual courtrooms what's causing their particular backlog, but that is an option. Then there's also an option of when people are in parish prison and they haven't been charged with anything actually billed. You get arrested. You haven't been billed with anything at that point, so you haven't been formally charged.
Okay.
You're just arrested.
Okay.
Now, law and order will tell you that you have been charged while you're sitting in parish prison, but you're not really charged until the DA actually bills you.
Okay.
So there is a process by which a judge can say, this person's been in parish prison. We need to bring him in. I'm bringing him into my courtroom. The DA can either bill him or we're gonna have to let him go.
Okay.
That process is there as well.
Okay.
But again, there's no one size fits all. There's no one size fits all for the judge's dockets because I don't know what's on those dockets. There's no one size fits all for what's causing the backlog. So sitting on this side of the bench now as an attorney, I know that the judge does have discretion with respect to either granting or denying those continuances, bringing people in and having the DA either, bill them or let them go, couple that with the bail and, bonding. When you put all those things together, the judge does have some discretion, but that's only from the bench perspective. You can't control what's happening in the DA's office and remember the people have to come before the court. They have to get there somehow.
Right.
So if the prosecution is not bringing them in, for arraignment, or they're not moving the case forward, or you have them both requesting continuances, the judge can only rule on what's brought before them. Either you have the people here, we've requested 10 continuances. A judge does not have to agree to that. And then you also have to look at how the caseload works. I may have 50 cases on my docket today. All 50 of them cannot go to trial.
Of course not.
So somebody is getting a continuance. So it just depends on what other cases you have coming. You can only try so many cases at a time. So when you don't try the other cases, then that means those people then are back in the pool of waiting for trial.
You've been practicing law for a long time. What is your estimation of the number of cases that can be processed in a court over the span of a year?
Oh, I have no way of answering that. None.
You can't ballpark it. You can't say, in my speediest year, we had so many cases. In my slowest year, we had...
No,
Okay.
because I'm not in court every day.
I
And I'm
understand
not
that.
in every courtroom every day.
But I'm trying to, what I'm trying to get to is there's a human factor involved in this. And we talked about this the last time you were here. I have a real concern, and it's not that I'm soft on crime. I think that I think some people need to go to jail. I have no problem with that. But I do have a problem with somebody being held. They don't have the money to pay bail, and their case is endlessly being pushed back because of understaffing. The DA says underfunding, and by the way, he says that the underfunding is not just in his office, but also in the public defender's office, which he also says is understaffed as far as attorneys are concerned. So you're understaffed in the DA's office, you're understaffed in the public defender's office, and you're underfunded in both offices. In the meantime, Johnny X is sitting in jail, arrested for a crime, but has not gotten what the Constitution says is a speedy trial. His life is going to hell in a handbasket. If he had a job, he won't have it too much longer. Right. If he had a family, he's estranged from that family, and more than likely, he has lost that family. How do we adjust what goes on in the judicial system in such a way as to help facilitate what the Constitution says is supposed to be a speedy trial?
Quite honestly, the understaffing of the public defender and the prosecutor, that is not a judicial issue. That's not the judge's concern. You know, my concern is, as you said, to protect the rights of people.
Okay,
so
it's not your concern. But if you are the judge sitting on a case and you have your own docket, you can say, Mr. DA or Ms. Public Defender, why are we still in this continuance phase? What is the holdup? What is it that we're looking for? And you can make a decision as a judge as to whether or not a continuance is appropriate.
Correct. And if I feel, again, my job is not to protect the public defender or the prosecutor.
Right.
Yeah, that's not my job. My job is to protect the rights of the people.
But you are a part of a system that has somebody caught up in it. Perhaps he's caught up in it by virtue of his own behavior. Perhaps he actually did something that would cause that to happen. Maybe 75, 80% of these people are. But there's a contingent of these people who got caught up in something not of their own making.
But all of those people.
And I am just concerned about that person whose life has been forever changed because he's sitting in parish prison and not working his job, because he's sitting in parish prison and not taking care of his family. And I keep saying he or she is sitting there and not assuming their responsibilities, the responsibilities of caring for their family and caring for themselves. And
I'm concerned about.
I'm not blaming judges. I'm just asking, is there something that a judge can do to help facilitate that? Because when I see 11 to 12,000 cases in backlog, that's not months, that's years that you're sitting there.
But let me just say this. As the judge, I am just as concerned about the person that you said is just caught up in the system and the one that you said may have gotten himself there. They still all have rights that need to be protected, whether they're there because they did something or whether they're there because you feel like, oh, they're just caught up in the system. They have rights, all of them. And the judge's job is to protect those rights of all of them, not just the ones that you feel like should be there, should be gone. All of them have the same rights. They have the same right to speedy trial. That does not apply based on the level of offense. I mean, everybody has that right.
I understand
so
that.
From the judge's perspective, the backlog or the funding or the staffing, that should not be the judge's primary focus. The focus is protecting the rights of the citizens.
Does a judge have discretion looking at the facts of the case as presented to the judge at that particular time to determine whether or not the case warrants going on or whether or not the case should be dismissed? Does a judge have that discretion?
You do. You have a probable cause hearing. In order for those people to be still in jail, you have to, the court has to have found that there was probable cause to hold them.
Okay.
So if a case comes in and there is no probable cause to hold that person, then the court is going to order them to be released.
Okay.
So we have to operate from the standpoint of everybody that is in Paris prison, we should have crossed that bridge already. We've established that there is probable cause to hold them. And so from that point, I said, we have to move those cases along. So then you have to kind of consider what's on your docket, the number of continuances. And for me, that's not going to matter. It's not going to make a difference to me about the DA being underfunded or the public defender being underfunded because people's rights are primary to that. And if they've been there and it's a case, you're going to have a prosecutor in a courtroom. You're going to have a public defender or a private attorney in the courtroom. Then the court can move those cases along. It's not going to, Hillamore or any other prosecutor is not going to be able to come to court and say, we can't hear this case today because I don't have staff to do it. Yeah, no, that's not sufficient. And I don't think he would ever do that. I don't think Hillamore or the public defender will ever say, Judge, we can't protect this person's rights because I don't have somebody to try this case.
So then what do they say when they come to a court and they ask for a continuance? They say that the investigation is ongoing, or they say that they're still in the process of gathering information. Exactly what do they say?
Those two things I've heard said. I mean, there's no way to say what's said on every case because all of those things have been said based on whatever the particulars are of that case. But when you look at a case from the bench's perspective, at least as far as I'm concerned, I have in front of me how many times this case has been continued. You can only say so many times we're waiting to complete the investigation. I mean, we're going to run out of times to complete the investigation because then the court's going to say, we're going to trial. This is your last continuance. So sometime between that time and whenever that trial date is, you're going to figure out what you need to do to be prepared for trial because at some point the judge is going to say, this is your last continuance.
As a judge, are most of your cases bench trials or are they jury trials?
I can't tell you as a judge because I'm not quite one yet.
I know
but
that,
I will.
I mean, your experience.
Right. The majority of cases are bench trials. If there's a trial, a lot of cases result in plea deals. There may be a plea agreement. People still do come in and plead guilty, or there's still pleas. So you have people that plead, you have people that have a bench trial, and then you also have jury trials, and then you have cases that are just outright dismissed because there's no probable cause.
Okay. So, in the case of a bench trial, you don't have to worry about holding juries over protracted periods of time. But in the case of a jury trial, if it's a felony case and they request a jury trial, how long can you hold a jury within a particular case, or do you have to change juries out if they're asking for continuances and things?
No, I don't know that. Look, it doesn't work that way.
It doesn't work that way?
No.
Okay.
It may be on TV, but in real life, once you impanel a jury, you keep that same one throughout the case.
Okay.
But remember, the jury is not impaneled until the case is called for trial.
Okay.
So
So there are no continuances once the case has been called for trial?
Absolutely not.
Okay.
I mean, it would be a rare circumstance because it wouldn't be a continuance at that point. You would be recessing the trial for one reason or another.
Okay.
But that's typically not done. Once you impanel the jury, then you are trying that case.
Okay.
And no, we do not switch juries out in the middle of a trial. You keep the same people. Now, there are cases where you've had alternates. I'm sure you've heard that you may impanel a jury and then you also impanel, alternates.
Sure.
But that's in the event that something happens to one of those juries, because at that point you don't want to start your case all over again. If I only, impanel 12 people, well, if something happens to one of them, then that means we start this case all over again because you can't decide the case based on the 11 that are left. So you typically always have alternate jurors, and that's the reason for those. But to switch the entire jury panel out in the middle of a trial, no, that's not ever done.
With regard to the policing that takes place within East Baton Rouge Parish or whatever jurisdiction your court sits in, do judges have input or conversation or conferences with law enforcement about how policing is done, about what factors take precedence within police policies, or is that left to the discretion of law enforcement?
Wait, I'm not sure I understand the question. Are you asking if the judge sits down and talks to the police chief about problems?
Occasionally, yes.
About
From time to time.
About a particular case?
No, about policing in general. Not about a particular case, but about policing in general. I have seen reports that certain segments of the community are over-policed and other segments of the community are under-policed, that people are arrested for the same crime at a much less rate by virtue of where they live, their zip code, as opposed to people who live in a different zip code. From my perspective, not a lawyer, it seems like there's something in the priority of policing that has to do with that. If statistical evidence shows that whites and blacks use marijuana at generally the same rate, but blacks are being arrested at 70% for marijuana and whites are being arrested at 30%, it seems to me like there's a priority on policing in one area, one zip code, as opposed to another. Can judges have input in that? Not telling, I know you can't tell the sheriff what to do,
no.
But can you have a conversation about that?
No. No. There's no alternative to that. The answer to that is no. Because the judges can't play any role in how policing is done or who's arrested or who's not arrested. We have judicial canons that are that's gonna prohibit that. So the answer to that is no.
Okay. As a citizen of the community, is that a concern of yours? That some zip codes, I live in 70808, and I used to live in 70807. 70807 is overwhelmingly black. And there are more people who are in parish prison right now who are from 70807 than there are from 70808.
Okay. As a citizen who is not,
I'm just wondering, does that concern you as a citizen?
as long as
Does that concern you as a judicial candidate?
As long as I'm not a judge, yes, I have those concerns like any other citizen would.
Okay.
How that will not and cannot affect anything that I do
So then that
once
leads
I'm
me
elected.
to the next question. How much advocacy can there be once you assume the bench?
None.
None.
None. I'm not an advocate anymore for either side. Remember, a judge can't be biased.
You're
either
the
way.
umpire in the courtroom.
For the cases that come before me.
You're the umpire.
Right. That means I'm not an advocate.
But when you go home, you're no longer an umpire, and you have judgment. You have thoughts.
Uh-huh.
You have perceptions. Uh-huh. You have ideas. You have beliefs. Can a judge not on the bench advocate for certain things with regard to law enforcement?
No.
So you give up that right to
Yes.
do so once you assume the bench.
Yes.
Not just when you're on the bench, you give up that right.
Because I'm a judge whether I'm on the bench or not.
Okay.
So even if I'm having lunch with you, I'm still a judge. I still have to abide by judicial canons, whether I'm at my house, whether I'm with you, whether I'm in the courtroom. Those canons still apply. So no, I can't, get off the bench, then go to lunch with you and have a conversation and say not just, let's say I'm with the police chief. I can't advocate one way or the other because I'm not an advocate anymore.
You can't advocate in general. I understand you can't advocate specifically, but you can't advocate in general about the way the policing is done?
No, I wouldn't.
You wouldn't?
Would not.
Okay. But the fact that you would not does not mean that it cannot be done at all.
I think it should not be done at all. I can't tell you the specific judicial canon that would prohibit that, but I would think that there is one that does.
Okay. So if I'm reading the paper and I read about a certain case that happens and this person is sent to jail, or this group is sent to jail at a higher rate than another group, and I'm reading the paper and I say, doggone it, somebody ought to do something about that. There's a problem with that. That means my Metro Council person could address it. It means my state legislator could address it, but I should not expect the judge or judges, the group of judges, to address it.
Correct.
That's what you're telling me?
Yes.
Okay. Do you think that it matters within the judicial system that people who are faced with such difficulty don't necessarily have the same level of appreciation for what a judge does? Because you're asking them to vote for you. Do you think that they need to be better educated as to what a judge does and what a judge does not do, what a judge can and what a judge cannot do?
Yes, I mean, there's always room for education, and that's one of the things I've said that has been, I guess, a bonus throughout this race and throughout my being a candidate. By being out talking to people, I've had the opportunity to educate the community on exactly what you said, what a judge does and what a judge doesn't do. And I don't want to say I've been surprised as to what people think, because like you, they watch TV, they watch Law and Order, and they think that's what happens in a real courtroom, and it does not. Oftentimes, most of the time, that's not how it happens in a real courtroom. So being out talking to people, I've now had the opportunity to educate them on what actually happens, and I think that builds public trust. Because see, one of the things that I found from talking to people is that they have a lot of concerns about what goes on in the courtroom because they don't know the process. So that causes them to immediately say, I don't trust the judiciary. I don't trust the judicial system. Well, a lot of that's alleviated when you explain, here are the steps. This is what happens. This is how this process unfolds. And then a lot of times that, changes that perception of exactly what's going on in court. So yeah, I personally had the opportunity, to educate quite a few people on what happens in court. And I don't remember if I said it on our forum, but what I'd like to do from the bench is a lot of times people are just sitting in court. You come to court, you're sitting there, the judge gets off the bench. The people in the courtroom have no idea that when the judge gets off the bench, that they're not just in the back twiddling their thumbs. You're still working, although it's not occurring in the courtroom. So there was a judge, I guess during my practice or when I practiced in court, she would always explain, when you open the court, she called the docket. When she got ready to get off the bench, she would always say, I'm taking a recess to do this. I'm taking a recess to meet with the attorneys, about your case. Well, when we come back in, we're going to do this. But with that explanation, then that does not allow people to sit in the courtroom and have no clue what's going on. I would much prefer a judge that tells me I'm taking a recess to go, to continue to work on your case, as opposed to I'm just saying, recess, I get off the bench and you don't know where I am. You just know I'm gone for hours. I want you to know that we're still working on your case.
Do judges, the current roster of judges in the 19th JDC, do they do clinics, workshops, community forums designed to educate the public as to what the job of a judge is, as to what the role of the court is, as one part of a larger judicial system?
I'm not aware of any, but I don't want to say that they don't occur. I'm just not aware of any.
Do you think that it would be beneficial to have such a thing?
I do. Yes.
You've said to me several times, it's not like on TV. And I understand that. But for
Now, that
most
doesn't even happen on
people,
TV, though. Let's be honest.
Most people, their only framework
Right.
is what they see in media, television, TikTok, or what have you. You don't, if you're not intimately involved in the criminal justice system or in the judicial system, you don't know,
Right.
unless someone tells you. And so you're left to your own imagination as to what a judge can and cannot do. And so I'm just curious if you thought it would be beneficial if these kinds of forums could be held on a regular basis that would help inform the public.
Yes, I do. And I would be willing to participate in that kind of forum. But as long as it doesn't involve specific cases or specific incidences, or you're not at, because what tends to happen is you're going to ask me about your case, or you're going to ask me about your cousin, or you're going to ask me about your brother, and I'm going to tell you I can't comment on those.
Right.
But as far as if there was a forum that's, let's just educate, it's the same thing with going into schools and talking to children. Judges do that all the time. They go to schools, talk to kids or high schoolers or, whatever age about what happens in court. That same thing can happen at a different age group. The same thing. If you have a forum and you say, we're going to bring these judges in and you're going to ask these panel of judges questions, there's no reason that can't happen.
One of the things that came out of the forum that we had last week is the number of specialty courts that exist within the 19th JDC. How many are there? Refresh my memory.
Let me see if I can think of all of them. You have pretrial diversion. You have another pretrial program. You have veterans court. You have domestic violence court. You have the reentry program. And I'm sure I'm forgetting at least one. Oh, and then you have commissioners court. You have the commissioners, and you have drug court. So, yeah, there are a number of special, and they're not necessarily specialty courts.
Okay.
It's not a separate court system.
Okay.
It's not like you have 19 JDC and then you have these specialty courts. Those are programs that operate within the 19th Judicial District Court.
Okay, so how does that work? If I'm a veteran and I am accused of a drug crime, I heard you say drug court.
So you go to
and
drug
veterans
court, or do you go to veterans court? Well, I mean, that's, I guess, one of the things that, based on whatever the circumstances are of that case, where you would be best handled. And you may not go to either. You may not either, depending on what the offense is, and you may not go to either one of those courts. But those are there as domestic violence intervention courts, for example. So if you have domestic violence cases that come, you have a different expertise that's like available in that courtroom, so that you can hopefully, prevent domestic violence or assist people who have been charged with domestic violence so that they're not repeat offenders. But those courts are designed to have, I guess, there are people that are, that work within that court system to address those particular issues. Which I think is helpful, as opposed to just going in general population court. You now have over here, people that this is the kind of cases that they have. You have programs, you have community services, you have services that you can offer that's based on that particular set of offenses.
I think I recall you saying that from your perspective, the mental health courts or the mental health aspect of trials that come before the court is something that is of a particular concern to you, how those cases are handled. It sounded to me like you were hinting that there's a mental health problem that exists within East Baton Rouge Parish. Do you think that the parish is adequately set up to respond to the mental health issues that ultimately might appear before your court?
Do I think that there are adequate services now to address
Yes.
the mental health concern?
Yes.
No. I mean, we're building. I mean, you can see that there are a number of programs that exist now that didn't exist 5 years ago. So society as a whole, we're now recognizing mental health issues and mental health concerns. So what I was saying was that also carries over to the judiciary. You know, as a judge, you have to recognize the whole person, which would include, you know, mental health aspects as well. So I'm not saying that it doesn't exist. We've come a long way. I mean, I can remember, you know, 5-10 years ago, you never heard anybody say anything about somebody having a mental health issue. You just dealt with the person and didn't consider that as a factor. But now, because it's so prevalent, I mean, we see so many cases, I mean, of all age groups, you know, people with, you know, mental health issues, that you have to address it, which I can say that, you know, I'm very pleased to see that it is being addressed.
Do you, once again, you're one part of a much larger system, but when families have a problem, a domestic issue with a person within a home, and that person is picked up, family calls the coroner, and the coroner says that this person is going to be taken to a facility and examined. A 72-hour hold is put on that person. When the person comes off of that 72-hour hold, more often than not, they're put back in the same situation that they were in before the hold took place. But now they're angry and embarrassed and humiliated about the fact that they were held. Do you think that in any way leads to worse behavior further down the line than perhaps achieving the end that you want to achieve? The idea, of course, is good. You want to diffuse the situation. You want to try to address the immediacy of an issue, but there's not a whole lot you can do in 72 hours if there's a true mental health problem.
Right, but
what's step 2 beyond that, I guess, is my question.
Because if there is a problem, you don't have to release them in 72 hours. It just depends on what that problem is. If that person poses a danger to themselves or to society as a whole, you're not going to release them in 72 hours. You're not going to say, okay, I know that this person is a danger to themselves, but 72 hours has passed, so I'm sending them home. No, it doesn't work that way either.
No, it does work that way. But we'll
Let me
more
say,
often than
it
not,
shouldn't work that way.
That's a different statement.
It should not work that way.
But my experience is it works that way, and I deal with families who have to deal with this issue on a regular basis, and they're picked up by the coroner and they're taken away for 72 hours. Let's double it. Let's make it 144 hours. Instead of 3 days, it's 6 days, and then they're released back into the same situation that they left. And now, in addition to the mental issue that exists, they're angry.
Right.
And they're humiliated and they're embarrassed. And quite often the situation is worse coming out than it was when they went in. Not saying that it is the court's fault. I'm asking what can be done, since you mentioned mental health, what can be done to better address mental health issues from your perspective as a jurist or as a prospective jurist?
Okay, so you mean within the court system. So once a person...
You're not just in the court system, Vicky. You're also a part of the community.
But I have to answer... My answer depends. I mean, I can give you my answer of what Vicky Jones thinks, who's sitting at home watching this, versus Vicky Jones, who is a potential judicial candidate and the judge. So what I can do as a judge... And then you have to also consider, like that person you identified, who's picked up on the 72-hour hold. The judge is not involved in that, you know, because you remember that person has never been charged with anything.
I understand that.
Been arrested.
But you did say a minute ago that it's not going to happen where they're going to be let out if they're seen to be a danger to themselves or to other people. But that's exactly what happens.
Okay, let me rephrase.
It is precisely what happens.
It shouldn't happen, but then separate that from a judge's role. Remember, that person that you're talking about that was picked up by the coroner and that was taken to be evaluated by the coroner, that person has never been in the court system.
I guess the question
the
that I'm trying to
judge
get
can't
to
address
is, in addition to being on the bench, what is the advocacy role of judges in the community that they serve so that you prevent things from... There is diagnostic care and there's preventative care. It sounds to me like the court system is set up for diagnostic care. This is what you did. This is what the problem is. This is how we're going to respond to that problem. As opposed to preventative care, where we do something, address issues before it reaches a place where there is an explosion. Before it reaches a place where someone commits a crime. Doesn't have to be before they do something wrong.
Okay.
And I'm wondering, as someone who sees this on a daily basis in the judicial system, do judges come together and talk about things that they can address from a more advocacy position as opposed to a diagnostic position?
I mean, unfortunately, I don't have the answer to that because I don't know what the judges of the 19th Judicial, I don't know what they do, behind the scenes and when they come together and what they discuss.
You guys have CLEs, right?
Oh, yeah, we do.
Where you all go.
The judges have them as well.
And you have seminars and you sit around and you talk about, well, this law was changed and that law was changed. Does anybody ever sit around and talk about what we need to do to help keep Johnny from ever arriving in jail in any of these CLEs? I'm just curious.
I don't know that it's officially talked about as a CLE. It won't be a CLE topic. Typically, when you go to the CLEs, you have various topics that you receive, CLE credit hours for. I don't think, I've never seen one that the topic is how to prevent something and you get some sort of CLE credit for that. Now, discussions that just go on a personal level, I'm sure that attorneys and judges have those personal conversations because, like you said, we are humans and we are in the society. So I'm sure that there are conversations that occur about what's going on. But from a judicial standpoint, you're kind of loading the question. You're saying the 72-hour hold, meaning that person has never come to court. So judge plays no role in that. Then you're saying, preventative measures. Remember, the person is only going to come to court after they've done something. So we have to kind of separate
and
those.
So I'm asking, you're talking about the diagnostic end of it from my perspective, as opposed to the preventative aspect.
Neither one of those involve the court. The court doesn't make any kind of
prevention helps keep it from getting to the court.
Okay, but separate.
And I'm asking, should judges consider themselves as members of the community with standing, with a certain degree of respect from you were elected to the office, which means you have a certain degree of respect from the community. Should judges utilize that respect factor in order to try to address mental health issues before they become something that has to appear in their court?
I mean, that's a really convoluted question. It's the classic case of...
It's complex, but it's not convoluted.
What is? Because you're mixing apples with oranges.
I'm not mixing apples and oranges. I'm saying that you are also a member of the community. And I'm a pastor whether or not I'm here in Shiloh. And I sit around with people and talk about community issues all the time. I don't just talk about them when I'm in the pulpit. I don't just talk about them when I'm doing Bible study. I talk about it all the time. And we try to find ways to address issues. I'm asking, do judges do the same thing?
You're not controlled by judicial canons. Judges are. You're not governed by a judicial canon. There's nothing that I'm aware of, that where you have a set of rules that you have to follow that are judicial canons. Judges do.
They're not judicial canons, but we do have ethics and we do have behaviors that we are expected to follow. We do have doctrine issues that we're expected to follow.
I got it. Expected to follow and mandated to follow are two different things.
So then ultimately the answer is no.
Yes.
Okay.
We're back to where we started.
Okay.
No. I'm sorry.
It's
frustrating.
It's frustrating to me because I have an expectation that judges can do more. And I'm really getting myself in trouble because I got a bunch of judges in this church. But I have an expectation that judges can do more than what they are doing with regard to certain issues. Wow, I just got myself in a whole lot of trouble.
And I'm going to leave you there by yourself.
So
I'm going to leave you there. Let you figure that out.
Tell me why Vicky Jones is the best of the 4 candidates who are running for judge.
Vicky
Look
Jones.
at that camera right there.
This one over there?
Yeah. And tell us why Vicky Jones is the best candidate of the 4.
Because I have 33 years of experience in the court system that I am seeking to practice. That experience is not, singular. I mean, I've tried cases on both sides, both as a prosecutor, and as a defense attorney. That's criminal cases. I've also handled civil cases on both sides, either as a plaintiff's attorney or as a defense attorney. I've handled cases at every level, from city court to district court, federal court, even, at the Supreme Court. Also, during those 33 years, I have life experiences as well. So I think that you need to combine those two. The things that I believe that a judge has to have: knowledge of the law. First and foremost, you have to have knowledge of the law. You have to have integrity. And then you also have to have an interest in protecting the public. You have to recognize that, people need to be treated with dignity and respect. And I think of the 4 candidates, I am the most qualified to do that.
You have a son who is about to graduate from law school.
Yep.
And I know his thoughts on this, but just your thought. Last question. Would you like to see your son remain in Baton Rouge? You're a Texas transplant, and you planted your flag here in Baton Rouge a long time ago. Would you like to see your son plant his flag here in Baton Rouge? Foregoing his own personal desires. I'm not asking you to think for him, and I know it's his decision. But if he said, I think I've changed my mind and I want to stay in Baton Rouge, would you be okay with that?
I'd be very happy. I would be happy as a parent to have him remain in Baton Rouge. But aside from that, I love my son to death. And Donovan has, I think, a lot to offer the community. And I think I would like to see him use that in the Baton Rouge community. That's the community, that I'm seeking to serve, and I would love him to see him use his talents here. But while I also respect the fact that he'd like to, take those talents elsewhere, I think Donovan is going to be successful wherever he goes. The things that I've seen from him and the potential that I know he has, I would love to see him use that in our community. I think he would serve our community, greatly, and I'd like to see us do that.
As this is being recorded, we are already in early voting.
Right.
The election day is when?
The election is October 11th.
October 11th. And so I want to encourage every person who is able to vote to please make sure that you exercise your right, your responsibility to vote. As I say all the time, people fought, bled, and died to give you that opportunity, and you should not waste it. You should make the most of everyone. Thank you for taking time to come and share with us today.
Can we add a few things?
Yes.
Early voting started on Saturday. It ends October the 4th.
Yes.
So let's encourage people to vote before then. Also, I'd like to encourage people to go to their Go Vote app, because with the redistricting, a lot of people are unaware, number one, that they can vote in this election. So I would urge everybody the first thing you need to do is go to Go Vote. 1, let's see if you are registered to vote. And 2, whether or not you can vote in this election, so that people come out to vote on October 11th or during early voting, as opposed to waiting until election day.
Okay. Thank you for coming by. Thank you for viewing. Thank you for listening. We'll be back again next time.